right. Hello, welcome back, and thanks for joining us. Today I want to cover a little bit about the difference between civil and criminal cases and the processes and how the courts work and how we can work them. So we're moving on beyond the step of understanding that we each are the power, we're the basically the Attorney General, but we're the Attorney Specific. So we are the ones that control the court, we are the Chief Justice, and we have the power to call the court at any time. So that means that wherever we go, we have the power. So now we have to understand which court we're in and how we're going to proceed through these courts. So we know that there's really only two types of actions, civil and criminal, and everything comes under that. And if it's there's lots of different kinds of civil actions, but there's only one type of criminal action. So when we divide those up into civil and criminal, the criminal part is usually used to be common law crimes, and now they're common law crimes and they're statutory crimes. And so I wanted to read a little bit about the statutory crimes, and those are those created by statute as distinguished from such as are known to or cognizable by the common law. So now we have two types of criminal statutory crimes and common law crimes. And the common law crimes are what they call the crimes in se, as opposed to the statutory crimes that are crimes that are prohibited. So we're working with the crimes that are prohibited, which are what we call victimless crimes. So we know how to get out of these types of crimes. They've made all the mala in se crimes also prohibited crimes. So those are now prohibited, so there is a way to get around those types of crimes too. But we're not really into that, and the procedures for real crimes, they do go back into the mala in se, I think, when you get into these higher crimes, and the court just proceeds the way they're supposed to generally. But really, a lot of these misdemeanor and felony actual crimes are now prohibited, and you can procedurally get around them. So what they did is they took these crimes that are prohibited and they put them into a proceeding that's called a special proceeding. So I've reduced it down to this special proceeding, and it's called a summary proceeding. This type of special proceeding, summary proceeding. And a summary proceeding is a short, concise, immediate, peremptory, offhand, without a jury, provisional, and statutory. The term, as used in connection with legal proceedings, means a short, concise, and immediate proceeding. So you know when you get a ticket or you get any type of a notice to appear in a criminal case, you're going to be going to a special proceeding where you're already guilty. So you show up there, you're already guilty. Now why are you guilty? Because you didn't solve your problem before you got there. It was that quick. Here you have your ticket, and now you're in a summary proceeding. So the only way that we figured to get out of that is to have that summary proceeding dismissed. And that can be done because it's a proceeding that's in a court that's not really civil or criminal. It's in this special proceeding, which is the summary proceeding, which is the minute you get there and enter in to either defend or try to defend or look like you're going to defend, you're already guilty. Now maybe you can pull a statutory stunt and the judge will grant you a dismissal if you have a speedy trial issue or some reason why he should dismiss it, but he can decide whether he wants to or not at any time, because it's a special proceeding and he's deciding, and you went in there. Because when we're running the court, we have to be the Chief Justice. We can't go into their court and try to run their court. We have to run our own court, and the way we run that is by staying out. So we know to stay out because it's not quite criminal. What is the criminal jurisdiction now? Criminal is that which pertains to or is connected with the law of crimes or the administration of the penal justice, and which relates to or has character of crime, of the nature of or involving a crime. So they're telling us now criminal, they're going to make their criminal kind of like crimes, sort of like crimes, because the common law crime is the one they're talking about, but they're doing the mala prohibited crime, and they're doing it kind of like the criminal. That's the crime or criminal. So when we go to look up what the word crime means, it's a positive or negative act in violation of a penal law, an offense against the state or the United States. So these are all prohibited crimes, because if it was a crime in se, it couldn't be an offense against the state or the United States, because you can't injure the state or the United States. You can't commit a crime against them. So they're saying that the United States or a state has put together by their Congress or Assembly a set of rules or laws that they call crimes, and they've just distinguished them. And in your federal, under Title 27, they've made all crimes commercial crimes. So these are not common law crimes, they're statutory or commercial crimes. So you're in a commercial court when you go in there and act upon one of their summonses. So we can quash the summons, the service of that summons, because in a criminal case there's no summons, but in a mala prohibited criminal case, they give you a summons. It's a short form called a notice to appear, because if it's a crime, you need a warrant. And so civil cases also are served by summons, and it's that summons that gives the court the personal jurisdiction. So when we get a summons or a short form notice to appear by a cop, the court doesn't have any personal jurisdiction. That would come by the warrant. So we walk in, and now you're voluntarily there. And if you're voluntarily there, then you have to leave, or you're going to be voluntarily convicted. It's that simple. You walked in, you're voluntarily there. The only reason you're there is really to get out. And then you attack their service of process. And then you attack that by saying, okay, you're going to quash the summons because the summons was issued improperly, because this cop just wrote it, and now he didn't state any jurisdictional authority of how he had jurisdiction over you. He was just hoping you'd show up and plead. So if we show up and we come in with a motion to dismiss and we challenge the jurisdiction of the court, now the magistrate has to make a decision, and then we can raise that up on appeal or by a writ. Because the question of law is, does the court have the authority to proceed on the subject matter and on the personal jurisdiction? And so those are the two things we need to understand, is that there's subject matter jurisdiction called in rem, and there's personal jurisdiction called in personam. And so when we come back next time, I'll talk about the in personam jurisdiction and the in rem jurisdiction, and those are the two jurisdictions we're challenging with this criminal court, because it's a special proceeding under the summary process where you've already lost before you got there. So we have to go back and exhaust that administrative remedy before we get to that court. And so next time I'm going to tell you how we're going to stay in the agency and not get up into that court. And if we do, then we got to have it remanded back there. And that's the process that we want to look at and understand, so we can negotiate with the cops and the judges and keep the remedy in our own court, which is the administrative court, which would be that police department or whatever agency the officer or agent is representing. Okay? Thanks a lot, and we'll talk to you next time.